All right, this is it. Provisional versus non-provisional. What's the difference? You've heard these terms: provisional patent, non-provisional patent. What do they mean? Okay, and what's the difference? Let's get to it right now. What is the major difference? Why do we need to know 12 months? Is it the non-provisional or the provisional that comes first? I'm JD Houvener, registered USPTO patent attorney, managing partner here at Bold Patents Law Firm. I am here talking to you about the key differences between the provisional patent application and the non-provisional patent application, and what you need to know before you make a big investment in your visionary idea. I have included a table of contents right here below. Fast forward, rewind, and go to the exact location in this video that will impact you the most and allow you to get in that quick 1 or 2 minute impactful value that I am going to present to you today. This is for you. If you're watching this video, you're with me, I need you to like and share this. Put a comment below. I will respond. I love feedback. This is how I improve. Why I'm doing this video is to make sure I give you quality content. I wouldn't do it otherwise. I've put together a blog article that goes into huge detail. I'm not going to get to everything here today on this video, but the blog article definitely does. And it's something I maintain from at least every couple months. I go back in and add or refine the content in these blog articles. Go to our website at boldip.com/free. Get your free book, Bold Ideas, The Inventor's Guide to Patents. While you get this book, which has got tons of information I've garnered over my decade of working in this industry, go to our blog page, okay? And go to the latest blog about provisional versus non-provisional patent application. It's got this mad scientist with crazy hair. You can't miss it. So check it out. In there, you're gonna see this awesome table that compares one column is provisional, one column is the next, non-provisional, and talks about, okay, what are the differences, the key areas? And we're gonna get to those right now. Number one, patent searching. Okay, do you have to do a patent search before filing a provisional? Yes, you do. How about a non-provisional? Absolutely. So either case, a provisional, you should know this, is a less formal, a more informal version of a patent application. A term that gets thrown around a lot is a provisional patent. There's no such thing as a provisional patent. Okay, there's no rights that accrue when you file a provisional. All right, a provisional simply encompasses your invention and all the alternative embodiments or versions of it. Anything that you can think of, right? The ways this could act and behave in different applications or different industries. And so one of the beauties is that you can have the drawings can be, engineering drawings. They can be photos, sketches, they can be hand drawn. It doesn't need to be overdone. It can take quite a while, and it should take a while to make sure you draw out all the different embodiments and to make sure it's fully disclosed. That's the provisional, and what's so important is you won't know what to write about. You won't know what to include and how to expand and what to go in detail on if you haven't done the patent search. Okay, the patentability search to cover worldwide prior art, covering anything that's ever been published before. Putting yourself in the shoes of the examiner, that needs to happen before you file certainly a non-provisional, and then even the provisional, because that really sets the stage for what you're going to be filing claims on later with the non-provisional patent application. So yes for both. All right, so next, how long does it take to do a provisional versus a non-provisional? Well, a provisional is generally, okay, depending on the technology unit, about half as complex, right? It takes about half the time that a non-provisional would take. And so we do, at our firm, we strive to perform provisional patent applications in 4 to 6 weeks, all right? Now don't forget that means that we need to have very, very good communication and cooperation with the inventor. Before we start working with an inventor, we don't know about the invention. And so they're the expert. It's our job to pull out of the inventor what it is they've created and to actually take it a little bit further and increase the scope. So it takes some time, and we have to write it all down and get some drawings to support that specification to make sure we can really have a full enabled invention. Enablement is the key legal requirement to what is required in that patent application. We must be able to show through writings and through drawings that someone could take that paperwork, right, that stack of application, and go build the invention from just what's filed there. Like I said before, non-provisional is going to take twice as much effort as a provisional. You've got to be able to identify all the different building blocks that go into a formalized specification. The background, the summary, the abstract, the detailed description, and the full claim set, as well as formalizing the drawings in terms of putting the flag notes and inserting those numerals into the detailed description. All that effort is going toward making sure that you have protected and made reference back to that provisional. So generally it takes twice as long. So we say for the provisional, 4 to 6 weeks, for the non-provisional, 8 to 12. And just know that if you worked with us on the provisional, we're going to be able to take all that work that you invested in, moving it toward the non-provisional. So don't think that work is lost. So if you've done the provisional effort with us, that's going to take away that 4 to 6 weeks. And so it's only going to be another incremental 4 to 6 weeks to do the non-provisional effort for you. So congrats on making that step if you have. So pendency, how long are these good for when they're in the process? A provisional is good for 1 year. That's it, 12 months. And so as soon as that 12-month timer comes off, it goes abandoned unless you file a non-provisional. Now, a non-provisional is good for as long as it takes until you get those patent rights granted. So if you argue hard with the examiner and duke it out, it could take up to 4 years. So be patient, know this is your time to work on your project, focus on the business, but we focus on arguing with the examiner and getting your patent rights secured. So attorney's fees, how much does it cost, right? Okay, let's get right down to it. Let's get to some numbers. I say between $2,000 and $10,000 for a provisional patent application. Non-provisional, $4,000 to $20,000. That's a big difference, right? Why? Well, a non-provisional patent application, the heart of what we're writing there is the formal specification with a detailed claim set. That claim set is everything. That's what you will be relying on later to enforce your patent if ever, for heaven forbid, you needed to go to court. That's exactly what the judge will look at, and the jury, if they're to determine whether you have found an infringer that is truly infringing on your product. They're not going to look at the pictures or the written description. They're going to look at the claims, and that's what matters, baby. So that's what we spend all of our effort on, is crafting those claims just perfectly, and then making sure we have a formalized set of drawings and specification to match it. Let's get to the USPTO fees. Depending on the size of your entity, and we're going to help you figure this out, but if you're a micro entity, meaning you make less than $160,000 a year and you haven't filed more than 4 patents, and you don't have any obligation to assign it to a larger entity, you can save 75% on your fees. For a provisional, you'll pay as low as $70, and a non-provisional as low as $480 or $500. Now, if you're a larger entity, you could pay as much as $300-400 for the provisional and over $1,000 for the non-provisional, but a drop in the bucket for a company of your size, right? So it's all proportional, and the government did that on purpose to make sure they have a sliding scale. One quick note, an international patent application, it's only applicable when you file the non-provisional patent application. It may make reference back to an earlier filed provisional, and that will allow you to then get the opportunity to file in any member country to that treaty. Know there's over 90 countries, any major country that's out there in the first world, even second world countries have signed on to this treaty. So really, there's no country that's really left out. Make sure that you be able to protect your invention overseas and abroad, and of course, including the United States. So it's been my pleasure to talk with you here today. If you've liked this content, I want you to give us a thumbs up. If you have any questions or comments, please include those in the comments below. boldip.com/free. I'm giving away for free Bold Ideas, the Inventor's Guide to Patents. This is your copy, a digital copy today. Please visit boldip.com/blog and look up the provisional versus non-provisional blog article. So again, I'm JD Houvener, USPTO registered attorney, managing partner of Bold Patents. It's been my pleasure to talk with you here today. I hope you all have a wonderful day. Go big, go bold.